Hi guys, it's Kathy. I hope you're doing well. So how did you spend your Father's Day? I hope if you're a father that you spent it nice, relaxed with a beer, maybe a fishing pole. I don't know. Hopefully you didn't spend it in initial appearances in front of a judge. Colorado had 3 different courtrooms open yesterday for initial appearances and 3 different dockets in each courtroom. Poor fathers are spending their Father's Day in jail. No, you didn't. No, you didn't. Michael sent me a video of a strong addiction that I have. I guess I need to seek therapy for Pez addiction. All right. Let's watch the first one. Okay, don't ask me which county in Florida because they're all the counties. We'll all the counties went into these 3 courtrooms yesterday in Colorado. And no, I didn't get the protesters. There were 17 protesters that were arrested on June 14th. They weren't in any of these courtrooms. But this guy was. This guy right here. This guy right here causes lots of issues.
All right, this case was issued on a warrant via affidavit. It alleges allegations including criminal mischief as a misdemeanor and second-degree criminal trespass, which is a petty offense. Do we have anyone present on this matter who is named as a victim in this case? I believe it involves a business.
It was weeds, man. It was.
That's all right. I don't want you to make any comments, Mr. Remington. I'm just asking to see if there's anyone in the courtroom. Okay.
I'm still getting used to how this all works.
That's okay. I understand. All right. I'm not hearing or seeing anyone, so let me hear from the district attorney, Mr. Krasner.
Yes, Your Honor. Noting that this is a first offense here in the state of Colorado, it does appear that Mr. Remington has a pretty extensive history out of Utah for multiple different types of offenses. We are a little bit concerned about ensuring his appearance in court.
Hold on, Mr. Krasner. Mr. Remington, this is not your chance to make comments. I need to be able to hear.
A really scary person. They're all misdemeanors and there are no actual victims. And
Okay.
I really not like how he's arguing about me.
Well, that's fair, but he's the prosecutor. He's not your attorney. I am going to hear from your attorney next. So give me just a moment.
Attorney, and then I may have one from the state because I'm indigent. I know how to defend my honor. I am Travis Mark Remington, Admiral of the Navy, sir, and I work with CIA. They just caught me out of your other holdings.
Okay, Mr. Remington. I'm going to listen to
Admiral Remington. Don't you listen? He is Admiral of the Navy, sir. Works with the CIA, sir. Don't call him Mr. Remington.
Mr. Krasner's argument. If you continue to interrupt, I'll have to mute you, okay? Please listen so that your attorney can make her argument next. Go ahead, Mr. Krasner.
Your Honor. Just given the lack of ties to the community, we are a little bit concerned about Mr. Remington's appearance in court.
All right, Mr. Remington, you're not listening to my directions, so I'm going to place you on mute. Go ahead, Mr. Krasner.
Thank you, Your Honor. So given that, we do feel that the recommended co-PR bond from the bond application makes the most sense in order to have some sort of assurance.
All right, I apologize, Mr. Krasner. Mr. Remington is not being compliant with the court's directives this morning. Mr. Remington, this is your last opportunity. Are you willing to participate?
He cannot participate. He's an admiral and his quarters are not spotless, ma'am. Please give him a moment.
Meaningfully in your hearing.
I saw that. Yes, Your Honor, I saw you moved to me. Yeah, I'm sorry when I hear people lie about me. I do have Christmas homes. My brother, I'm married to his sister Caroline.
Okay,
Yes,
Mr. Remington,
no,
this is my last advisement. You have to be quiet and listen so that I can hear the argument made by Mr. Krasner. If you can't do that, we can't have your hearing and then I can't set bond. So if you can listen quietly, and then your attorney will be given an opportunity to make her argument. Understood?
Yes, Your Honor. Do you mind if
Okay.
Officer Pippin Manley here just mutes it? So I don't inadvertently.
He asked for it, Ginny. He said, "Can you mute me? Can you just mute me? I'm just going to talk whenever I want to talk. So listen, just mute me, please."
Myself.
Sure, we will mute you. Please stay at the window and pay attention. Go ahead, Mr. Krasner.
Thank you, Your Honor. As I was saying, I do believe that a co-PR bond would be most appropriate to be able to assure that we can get Mr. Remington to appear for court, given that lack of ties to the community. But I don't think that a cash bond would necessarily make sense given the level of offense here. And I would ask, as an additional condition, that MIPS be authorized. I know that wasn't recommended in the bond application, but I do think that would be appropriate here.
Pretrial in general wasn't recommended. Are you in agreement with that, or do you think it's necessary on this case?
I think that given some of the behavior exhibited by Mr. Remington, both in the affidavit and as we've seen here in court today, I do think that standard pretrial services would probably be helpful.
All right, thank you. Ms. Steele, on behalf of your client.
I would be requesting a personal recognizance bond. Mr. Remington has lived in Colorado since November of last year. He informed me he receives Medicaid benefits. He just got out of Summit Stone. He also receives SSDI and has applied for food stamps. I'll also let the court know I do have some competency concerns that I'm going to let my office know about, but I would be requesting a personal recognizance bond for this case.
All right, thank you, Ms. Steele. Mr. Remington, can you hear me? I'm going to list your bond conditions, okay? I'm going to set bond in this matter as a $1,250 personal recognizance bond. I understand the people's request for a co-signer here. However, I think with the addition of pretrial supervision, the court can assure the community's safety via less restrictive means. Therefore, having ordered a personal recognizance bond, when you are released, sir, you will be required to comply with the following. You must participate in pretrial supervision at the standard level. You are ordered not to possess or consume alcohol, drugs, or recreational marijuana. I will further authorize participation in our mental health support program. I will require pretrial to monitor your sobriety, utilizing random UAs or BAs as necessary. Additionally, you must remain law-abiding, and you are now subject to a mandatory restraining order, which indicates you shall not harass, molest, intimidate, threaten, or retaliate against any victim or witness involved in your matter. I'm unmuting you, sir. Do you have any questions about the bond or the conditions I have just set?
Yeah, it looks like I need to go and get an official medical license for cannabis because there's no way you guys can get my medicine away. That's what I
Okay.
do.
And I did not restrict medical marijuana, so if you do obtain that from a doctor and are using it.
It's called cannabis, and you are not going to do that. I will
All
get.
right, sir. Your next court date is going to be July 1st at 1:30 p.m. in the Loveland Courthouse Division L1. Thank you, Mr. Remington.
Thank you, Your Honor.
Admiral, ma'am, come on.
Deputy, do you have a preference on the
Do
minute matter?
better. Okay, let's go to Alejandro.
Are you Alejandro Gomez?
Yes, ma'am.
Good morning, Mr. Gomez. My name is Judge Ryan. I'm going to set bond for you this morning.
I am in love with that name, Alejandro.
Mr. Gomez is before me on accusations including driving under the influence. I've appointed Ms. Steele to represent him this morning. Ms. Steele, did you have an opportunity to advise your client?
Yes, Your Honor, and I would be able to waive further advisement at this time.
Thank you. Let's go forward with setting the bond here. This one did involve a neighbor, but I don't think there were any accusations where they would be a named victim. So Mr. Krasner, I'll hear from you.
This is Mr. Alejandro Gomez, correct?
Yeah,
Okay, I believe this is a DUI, Your Honor.
yeah, the car was left in someone's yard.
Oh, yes. Okay, I remember that aspect now. Okay. So people, again, similar to the earlier DUI case that was before the court, are concerned about community safety. He was pending on another DUI from 2 weeks ago when he picked this one up. He was so uncooperative with law enforcement that they were unable to execute the warrant for his blood at the actual hospital. He was fighting them and medical personnel and threatening them in order to prevent execution of that warrant. So we do have some pretty significant concerns, both with community safety, as he seems to be unable to conduct himself safely on our roads, but also with following and abiding by court orders, given that sort of fighting all of those individuals. So we are asking for a secured bond in the amount of $350 cash, with all other terms and conditions that have been outlined in the bond application.
$350 for
Mr.
his
Casting,
second
Ms. Gill.
DUI.
I would be requesting a co-PR bond as recommended in the bond application. To support that request, Mr. Gomez has lived in Colorado for about 10 to 11 years. He works at Blue Sky Restoration. He has his siblings and his parents in the area. Really no criminal history other than that case that he is on bond for. I'll point out no failures to appear, no failures to comply on the application. He would be able to get a co-signer. I also wanted to let the court know that he has a pretty young baby, 7 months old, and he would really like to get out and be able to support his child. So for that reason, I would ask for a co-PR bond.
Thank you. I can certainly appreciate your attorney's comments, Mr. Gomez. However, the court here is looking at an individual who has accumulated 2 allegations of driving under the influence in a very short period of time. I'm also looking at the behavior that occurred once you were contacted by law enforcement, and it certainly seems to indicate a high level of intoxication and a lack of regard for the safety of those officers. For those reasons, the court cannot ignore the threat that you pose to community safety by choosing to continue to imbibe alcohol and be behind the wheel of a vehicle. For that reason, I will find that a non-secured bond is appropriate. I will set bond in the amount of $3,500 cash or surety. I will order that you comply with enhanced pretrial supervision. I want them monitoring your sobriety, and you are ordered not to consume or possess drugs, alcohol, or recreational marijuana. I will order that they use random BAs and UAs twice a week with ETG authorized. I will further order, sir, that you must not drive the vehicle unless you have a valid driver's license and insurance for the vehicle you are driving. The status of your license.
And please try to go 3 whole weeks without a DUI this time.
Certainly could be in jeopardy at this point, so you need to verify that through the Department of Motor Vehicle before you get behind the wheel of a car. I will order while you are on bond in this case that you are not to drive with anyone under the age of 18 in your car at any point in time. You are now subject to a mandatory restraining order, which indicate you shall not harass, molest, intimidate, threaten, or retaliate against any victim or witness involved in your matter. You are ordered to remain law-abiding while you are in the community, which means no new driving offenses or traffic-related charges. Further, I would order that you report to pretrial within 24 hours of your release, and that you check in with probation 24 hours after your release to let them know that you have had a new law offense. Do you have any questions about the conditions of bond that I have set for you?
Cash surety, is that the bond where you pay 10%?
You can use a bondsman and they will charge you a percentage. That's correct.
Okay.
All right. Let me get your next court date here. One moment, please. I apologize. I'm missing a document. One moment. There it is.
Also, are bail bonds companies open on Sundays?
I can't answer that for you, sir. The deputies may be more helpful in answering that question. You'll need to return to.
Yeah, they ain't open on Father's Day. No, I bet they were. They want money, lots and lots of money. Yeah, but lawns are so much easier to hit when you can't find that driveway.
We're on June 25th at 1:30 p.m. in Division 3D. Just so that pretrial is aware on this enhanced supervision, I expect strict compliance with the monitored sobriety and would like the court to be informed as soon as there's a missed or positive test. Thank you.
Mr. Hall, Your Honor.
All right. Are you Marquise Hall?
Yes, ma'am.
Good morning. This is 25 CR 5152.
No,
My name
no,
is
we don't need him. We don't need Marquise Hall. Don't worry. We need her. This one got me so mad. This one got me so mad.
Ms. Steele. Have you had an opportunity to advise your client?
Yes, and I can waive any further advisement at this point.
Thank you. Ms. Ryan is before me this morning on a domestic violence accusation involving misdemeanor assault. This was issued via affidavit on a warrant. Do we have anyone present in the virtual courtroom who wanted to be heard as an alleged victim today?
Yes, Your Honor.
Okay, what is your name, sir?
Marcus Linane,
Spell your last name for me.
Linnane.
Thank you so much. What would be most helpful for me to hear from you today, because the only purpose of today's hearing is setting bond, is how restrictive or how lack of restrictions you would like on that bond. And then the court is obligated to issue a mandatory restraining order, but that can vary from being as severe as no contact whatsoever with like a GPS tracker, all the way to as lenient as simply prohibiting harassing contact. Go right ahead with any comments you have, sir.
Yes, I would like a no contact order to start. And also, Miss Ryan is a high flight risk. I was told that last week she was out around town at the bars to have a going away party, and she was planning on leaving state lines before she was caught for her warrant. And yesterday, her parents showed up at my house unannounced, asking me not to be here today to speak to you so they can get her out of state. So she's a high flight risk, and I just want that to be stated.
Okay, thank you, Miss. Thank you, sir.
Thank
Anything
you.
else? I can't see you, so I just want to make sure I'm not cutting you off.
I guess it's not an isolated incident, and alcohol has always been a factor. So I should just like to state that as well.
Okay, thank you very much, sir. I'm going to hear
Thank
from the
you.
district attorney now. Their recommendations may be similar or different than yours, but I will take all of the information I'm given this morning into consideration. Okay, sir?
Okay.
Mr. Krasner, please go ahead.
Thank you, Your Honor. I also, as pointed out, noted that there is a history out of Illinois for similar types of behavior. We are a bit concerned about that. And given the comments that were just made, I was not aware that was the status of Ms. Ryan.
I loved the flying nun. I thought that was great. I loved Gidget better, but I love the flying nun.
As to how long she's planning on staying in the state. So that being said, I do feel that it's appropriate, just given the fact that there aren't really any other criminal history here in Colorado, that we do have a PR bond, but I was going to ask for a higher amount, in the amount of $2,500 in a PR bond. We would like standard pretrial services, no alcohol, drugs, or recreational marijuana, with sobriety to be monitored. We would ask that Ms. Ryan get permission before leaving the state. Not necessarily that she can't leave the state, but just that she gets permission from the courts before doing so. We would ask for the required domestic violence firearms relinquishment, as well as no contact as requested by Mr. Linane.
Thank you. Ms. Steele? Oh, you're cutting out, Ms. Steele. Let's try one more time. Go ahead.
She's
You're
a
not muted,
professional
it's just
too.
cutting out.
Is that better?
Yes, yes.
Okay, perfect. So I would agree that a personal recognizance bond is appropriate to ease the court's concerns about the possibility of her being a flight risk. Just to give some more context, Ms. Ryan has lived in Colorado full-time for 6 months. She was long distance with her boyfriend for a few years, coming back and forth before she moved here, although that was her only connection to Colorado. So when they broke up, she did plan to move back to Illinois, where her whole family and her whole support system are, not to avoid the consequences of this, but just to be around her support system. She does have a small criminal history from Illinois, but they are all misdemeanor cases. She assured me she would have no trouble coming back to her court dates in Colorado, staying in Colorado as long as she has to resolve this. So I would request a personal recognizance bond in this case. And I agree that the provision to request permission before leaving the state would alleviate any risk of her being a flight risk. Thank
All
you.
right, thank you.
I'm thinking the judge didn't hear what the ex-boyfriend just said. That's the only thing that makes sense to me. And this isn't the one that ticks me off. Immediately after she's done, the next one really gets me mad.
Your Honor,
Oh, yes.
she has been here longer than 6 months. That's a lie. She's lived at my house for 2 years. I just want to state that.
Okay, thank you, sir.
Thank
All
you.
right, this court has quite a bit of information before it this morning. I'm looking here at a defendant charged with a misdemeanor as an act of domestic violence with some out-of-state criminal history. I'm not aware of any failures to appear or issues attending or complying with court orders. I also note this defendant ranked as a CPAC category 1 with a score of 4. That's an instrument the court relies upon to indicate the level of risk of non-appearance. At this point in time, Ms. Ryan, I will find that a personal recognizance bond remains appropriate. I will set that in the amount as requested by the people at $2,500. What that means is you will be released today by promising to reappear for court alone. However, if you fail to appear in the future, you will then owe the
That's a great idea. That's a great idea. She's definitely not going to run. She is definitely not a flight risk.
court system $2,500. Understood?
Yes.
While on bond in the community, you must comply with the following conditions. You are ordered to participate in pretrial supervision at the standard level. I will authorize participation in our mental health support program if that can be of use to you. You must
All
not consume or
day
possess
long.
alcohol, drugs, or
Yes.
recreational marijuana, and I will order that pretrial supervision monitor your sobriety utilizing random UAs and BAs. I will further order that you are to check in with pretrial within 24 hours of your release, and that you must check in with them before you leave the state of Colorado, and that at all times when you choose to leave the state, you must have permission from pretrial to do so. You have been charged with an act of domestic violence here, so under Colorado law, I am now required to relinquish your right to own or possess a firearm or ammunition. Do you currently own or possess either of those?
No.
You must swear on an affidavit that that is true before you leave custody. If at any point while this case
You got to swear in the affidavit. That's true. Yep.
is pending, you attempt to possess or do in fact come into possession of those items, you will have violated this court's order and could be subject to further prosecution or revocation of your bond. You are also now subject to a mandatory restraining order which indicates you shall not harass, molest, intimidate, threaten, or retaliate against any victim or witness involved in your case. I will order a full no contact order naming Marcus Linane. No contact means no contact in person, no contact via any electronic device, and no contact through a third party.
Like
I will
your
order that
mommy.
you remain 50 yards from his person and residence at all times, and that you vacate any shared residence. I will authorize a one-time civil standby, which means you can contact law enforcement if you need to retrieve undisputed personal property from his residence. You would be accompanied by law enforcement to do that, and otherwise have no lawful ability to be at his home. Understood?
Yes.
The firearms provision and no possession of alcohol, drugs, or recreational marijuana will also be conditions of that order, meaning that if you violate them, you could subject yourself to revocation of your bond, but you could also subject yourself to a new crime of violating a protection order. Any questions about that?
No.
Okay, those will be the conditions of the bond that I'm setting here. You will need to reappear for court on June 23rd at 1:30 p.m. in Division 5D as in David. Some divisions do allow for virtual appearances. You are ordered to appear in person at this time. And if you are asking to appear virtually, you'll need to seek that express permission from the court that you are appearing in that. Understood?
Yeah.
Judge, honey, she's going to need to appear virtually because she's not going to be in Colorado. She's going to need that Zoom link, please, and the password.
All right. Thank you, Ms. Ryan.
Ms. Swanbomb, Your Honor.
Thank you. We will handle Ms. Swanbomb's matter and then we will take a break.
This girl gets me so mad. She gets me so mad. And one of the reasons she gets me so mad is because I had a complete and total bitch on Friday night. It was Friday night. we were slam packed busy. We had abandoned. And this huge table, we have a table of 10. We have a table that seats 10 people. So, of course, 20 people decided to sit there on Friday. And 18 of them were our regulars. Okay. One of them was, I don't know if you remember, it was a couple of months ago. I was working and this elderly man was sitting at this table, and all of a sudden, like he like stiffened up and he was about to fall over. And I ran across the restaurant and we got him to the floor. And he was non-responsive, but the nurse was there. Remember, the nurse was there. If you don't remember, I can't retell the whole story, but there was an angel there, and the angel, saved the day, because I was ready to go to town. And my hands were like this on his chest, ready to start CPR. And she very calmly, very easily, she just touched my hands, and she says, "No, wait." And I'm like, "Wait, what do you mean, wait? He's dying." But he just started, he wasn't breathing, he wasn't doing anything, and he just started breathing again. This happened a couple months ago. Okay. So the man had a medical issue where he couldn't lay straight back. So we got him to the floor. I got him up on my lap, and I was like trying to get him talking, and his wife was there. And then the ambulance came in and took him away. Well, Mother's Day that just passed, the wife was the only one to get me something. She got me this beautiful, bouquet, this thing of flowers. It was a plant, not just flowers. It was a plant. It was beautiful. So Bill, the guy, the older guy who fell over, and the wife came in, with 20 of their friends to sit at this table of 10. And all of them we knew. All of them are regulars. We had laugh, we have fun with them every time they come in. But they brought 2 new people this time. And before these 2 new people even sat down, it was a Friday night, we were busy. I told them, "You will have to separate your check at the end." There was no way for me to separate it, because they were all walking around. They got their drinks. I charged their drinks to that table, but they were mingling and walking around, and this person was at this table and that table and this table. There is absolutely no way for me to know who drank what drink from that. None. Zero. I was busy. It was Friday night. The end of the night comes, and she threw a fit, and we threw down. We were not nice to her. We did not treat her with respect. She started it. She came with this attitude, and really created a whole mess for the whole table and that whole check. So, I mean, spoiled, entitled. She's like, she shows me the bill, and she's like, "How am I supposed to know which are mine?" I said, "You drank them. You ate the food. How am I supposed to know what you ate?" Look around. Look how many people are here. I do know what she ate. She ate a wedge salad. Anyway, that's besides the point. I was not going to split it for her. So she got into a fight with Jessica, my niece. Jessica was great. She got into a fight with my daughter first. Then Jessica came over to save my daughter. And the lady's like, is that your manager? She said, "That's my daughter." And my daughter says, "Yep, that's my manager." And the lady says, "Well, is there no one else I can talk to?" And Jessica slams her hands down, grabs a business card, and throws it on the counter. "There," she said, "email the owners. Go ahead. Email the owners. My name's Jessica." So it was traumatizing. That one was traumatizing because other issues happened around that whole check because of her. Well, then I watched this clip. This happened yesterday. So the The bitch was Friday night. Saturday night we were packed and nobody was mean, but I was still PTSD. So Sunday morning, I'm getting these clips, which was just yesterday, and I'm like, oh my gosh, this lady, she reminds me of this other lady so much. Spoiled, entitled. You'll see. You'll see.
After that for my staff. This is 25T5170. Miss Swanbomb, is that how you say your name? 170. Miss Swanbomb, is that how you say your name?
It's Swanbomb.
Swanbomb. My name is
It's
Judge Ryan. I'm going to set
spoiled.
bond for you at this time. I've appointed Miss Steele to represent you. Did you have a chance to speak with her?
Yes.
Excellent. Ms. Swanbomb is before me on accusations of it driving under the influence, as well as no proof of insurance and traffic infractions. Ms. Steele, did you have an opportunity to speak with this defendant?
DUI.
Yes, Your Honor, and I could waive further advisement at this time.
Thank you so much. Let's set the bond then, Mr. Krasner. Let me hear your recommendations, please. Oh, you're muted, sir.
I'll get the hang of it before the end of the morning. Ms. Swanbomb is on probation for her first DUI. She was pending on her second DUI when she picked up her third DUI this case. That leaves the people with huge community safety concerns. I don't believe that a co-PR bond or a PR bond would be appropriate given that. And we are asking for a $250 cash bond, standard pretrial.
That pisses me off right there. That pisses me off. Oh, I don't care. I hope she is. I hope you are. Nope, don't say that here. So she got a DUI and was convicted. So she either pled guilty or was found guilty. And then while she was on probation for that, she picks up a second DUI. And this is her third. That one's not even done yet, and this is her third. And the prosecutor just said $250 bond. What? Do you want her to thin out your population? Is that what you're trying to do here?
Services and the other terms and conditions that were recommended and are outlined in the bond application.
Thank you. Ms. Steele.
I would be requesting a co-PR bond in this case.
And now she wants a PR bond. Careful's my middle name, Kit Kat. Careful now is my middle name. So both of those bonds are ridiculous to me. So I'm already slightly pre-annoyed at what's about to happen.
Report that Miss Swanbomb has lived in Colorado since about 1999. She has 2 kids that live in the area. They're both adults. She does not have a job at the moment. She is seeking disability. She's really been having a lot of challenges since her husband passed away 6 years ago. She only has the 2 cases that the district attorney just pointed out.
Oh, that explains it. 6 years ago, her husband died. So yeah, okay, I get it now. I get it. She can't possibly function as a human being yet. She needs more time.
She has done AA on her own, and she even used to be a sober companion. She let me know that she was sober for 9 years. She does have a cell phone to get text reminders about court, no failures to appear, no failures to comply in the past. She would not be able to afford any amount of cash bond, and she does receive Medicaid as well.
Thank you, Ms. Steele. Ms. Swanbomb, the court has listened carefully to the argument made by your attorney here, and I recognize that you are in difficult financial circumstances. I also understand that you have achieved great periods of sobriety, but it seems obvious to the court, based upon the track record here of being on probation for a DUI in Boulder, having a pending DUI in Weld County, and now this new offense here in Larimer County, that you are not currently in a period of sobriety. That substance abuse seems to be causing you quite a bit of trouble at this point in time, ma'am, and I simply cannot ignore the level of risk that presents to the community when you choose to use and then choose to get behind the wheel of a vehicle. For that reason, I am not going to allow for a non-secured bond. I will set bond in the amount of $5,000 cash or surety. You can contact a bond.
Not great. 5,000 is not great, but it is way more than the prosecutor or the defense attorney asked for. And thank you, Judge. Thank you.
Person and see if they can assist you in posting that bond. Otherwise, you will need to post them out in full. I will require that you comply with enhanced pretrial supervision. And I will order that you not consume or possess alcohol, drugs, or recreational marijuana. I will order that they monitor your sobriety utilizing BAs and UAs twice per week with ETG authorized. I will further order that I will authorize participation in our mental health support program. I will order that you are not to drive unless you have a valid driver's license and insurance for the vehicle you are driving, which certainly at this point in time, that status of your license is not valid. I would further order that you remain.
But her husband passed away 6 years ago. Judge, be nice.
Law abiding, which means you cannot pick up a new offense and be in compliance with this bond. I want you to report to probation in Boulder County within 24 hours of your release that you have had this new offense. I want you to check in with my pretrial within 24 hours of your release as well. Do you have any questions about those conditions?
Yeah, somebody will be able to write this all down because I have no memory capacity to have this. I don't know what I'm gonna.
I'm sorry, ma'am. I think what you meant to say was, oh my God, I could have killed someone. I could have killed someone with my actions. I think that's what you meant to say, not complaining that the conditions are too hard for you to remember.
I do.
Absolutely. When you check in with pretrial, they'll go over each of those conditions with you, and I'm certain they can provide it to you in writing as well. Okay.
Okay.
You'll next be in court on June 25th at 1:30 p.m. in Division 3, D as in David.
I don't even know how I'm supposed to go to Boulder. So.
All right. Thank you, ma'am. Okay, let's take a break.
I don't even know how I'm supposed to get to Boulder. How am I supposed to get to Boulder? She could have killed someone over and over and over again. All right, this one is a different docket. Okay, but again, it's a whole bunch of different so that's Denver, I'm pretty sure. That's Boulder. So it's not one county in Colorado. It's a whole bunch of counties. I know something happens here, but I don't know what. I didn't edit this one. We're just gonna watch it for a bit. I don't think it started yet. No. Almost.
967 appears from Arapahoe or from Delta County.
Delta. Oh, I haven't got Delta.
Brandon Rosenback for the people.
And Pound Land on behalf of Mr. Navarro, who is present via WebEx from Delta County.
Okay, looks like he appears after an FTA warrant back on June 10th.
And I can just jump in, Judge. We're going to reserve bond argument in this case. Mr. Navarro would like to resolve these as soon as possible, so I'm hoping that we could perhaps set this on either the jail docket later this week or into a division, but as quickly as possible so that we can get it resolved.
All right, thank you. Mr. Rosenbach, anything?
No, Your Honor, nothing further.
Okay, let's see. Peyton, what would be a good date, please?
That's not an inmate on a forest. Is it? I don't know. They look like, I can't tell. I'm going to go with it is. It makes me feel better.
All right, we can hear the case. I'm being told June 20, 2025 on the jail docket.
That would be perfect. And if we can also pull in 25M998 as a petty offense that he has in Boulder as well.
$25M998. Okay, we'll try to join.
It's with my passport
with the
somewhere.
virtual rate to Delta, please.
Okay, we'll do a writ to Delta by WebEx, and we'll take it from there.
Thank you. And if Mr. Rosenbach, if you could just flag for the misdemeanor attorney that we're trying to ECR, that would be awesome.
Perfect, I already did.
Thank you.
That's a different backdrop.
All right, thank you,
He's a clown.
Delta deputies.
Judge, I'm sorry to interrupt. I see that he has one more case as well. Looks like 25M 1000 that has a future court date in FAC.
Let me see what that is to make sure we can still.
Thank you, deputy.
Oh yeah, I think we should still be able to resolve them. So if we could just put them all on that date, that'd be great.
Okay, so we'll attach that 25M 1000 as well.
And that's for Mr. Navarro.
Yeah.
Okay.
June 20, 2025, 1:30. All right. Thank you. The judge will see you then.
All right. Thank you, Your Honor.
Okay. Have a good Father's Day. If anyone's a father there.
Thank you. Ready? Okay.
All right. Then we have Ebony Salcedo appearing from Arapahoe County.
Hi.
All right. She was picked up on an arrest warrant for theft. Bond was set at $5,000. Ms. Land, any argument?
Yes, Judge, I would be asking the court to modify the bond that was set on the warrant to $1,000 secured with a $100 cash option. I understand that she has some criminal history, but there are a few reasons that I think this is appropriate. So she was recently sentenced to probation in Arapahoe. What she tells me is that she's going to be released to sober living, specifically the Hazelbrook, I think the one in Aurora. And my understanding is that she's not going to be able to be released until she's picked up from a staff member from that location. So they've arranged all of that so that she has somewhere stable to go. My understanding is that she's been in custody for about 4 months now, but that probably when they're about to release her, they saw that she had this warrant pending and arrested her on it. She has a lot of things set up in the community. She has therapy set up, mental health care, really doing everything she can. We talked about the fact that she is going to have to, of course, appear for court in Boulder. She shares that her sister can help her with transportation to and from court while she is working on her sobriety and mental health. Historically, she has had a job at the Denver hair salon and is hoping to be able to start working there again when she's out of custody. So I'd ask the court to lower the bond so that she is able to post it. I think she should be able to post that $100 bond. If not, I'm concerned that she's going to lose all opportunity for this sober living facility.
All right. Thank you. Mr. Rosenbach.
Judge, I would ask for the bond to remain as set. I understand it sounds like there's a good plan for Ms. Salcedo, but the allegation here is a robbery. Looking at recently, she's had 3 felonies since 2017, one of which landed her with a lengthy prison sentence. And it looks like she's out and back to committing crimes. Frankly, I think there's a concern for the community. If there is some sort of plan for her to be picked up by a team and transferred, then generally what we see is a request for a bond that suspends when that team is going to come pick that person up. But what I'm hearing is that we're trying to trust Ms. Salcedo with simply being on a personal recognizance bond, then coordinating with these different teams and getting this done on her own. And frankly, I don't have faith in that. And I think the bond should remain as set.
All right. Thank you.
And
I think Ms. Lamb was asking for $1,000 secure bond. I usually am amenable to these type of releases when we do have a warm handoff, as Mr. Rosenbach mentioned. So what I'm going to do is keep the bond as set, but if there's a plan for a warm handoff at the next court appearance, you can raise that with the judge, and I'll make a note to the judge. And let me just get the next court date for you. Okay, June 17th, 2025, 1:30 at the county jail. And we'll issue a writ to Arapahoe if she is still in custody there. All right, anything else, counsel?
Nothing for the people, Your Honor.
Not from friends.
Okay, thank you, deputies there in Arapahoe, and we'll see you in court June 17th, 1:30.
Oh wait, sorry, Judge. I actually did have a question. I apologize. When I looked at the warrant, it said $5,000 secured with a $5,000 cash option. What exactly is that supposed to read, or what is it now?
It should be 5,000 with a $500 cash option.
Okay, thank you.
We have to have a lot of fake holidays all of the time. That way we can go shopping and buy stupid crap no one's ever going to use. That's what we do here. It makes us happy.
Sorry for raising that.
No, I'll just make a correction there. All right, thank you.
Thank you. Okay. Am I able to call a couple cases out of order and then we can go back to the regular docket?
Yes, you can. The jail had a request, but as long as you're not stepping on their toes, that's fine, Miss Land.
I think it's the same request. Can we call Mr. Marlo Gado?
We'll get to see if that lump gets up off the floor. Move out of the way. I'm trying to look in that room. Nope, it's still on the floor.
Can you catch the last name? Oh, hold on. Gotcha. Thanks, Peyton. Yeah, we have 25M1217.
Happy birthday, Dad.
And Your Honor, Brand Roseback for the people. I can state that I do have some concerns given the recent criminal history and VPOs, but ultimately, given the allegations in this case and the charges in this case and the level of charge, I'm not objecting to a personal recognizance bond on this case.
Okay, great. Thank you for jumping in. Ms. Land, anything?
If it's inclined to set a PR bond, then I don't need to make it for the record.
Yeah, I'll set the PR bond with a placeholder $1,000 amount. No alcohol, no drugs, no weapons, substance abuse monitoring at probation's discretion, drug monitoring at probation's discretion. And we'll get a date for him to come back. I'm being told July 24th, 8:30, courtroom B, as in beta.
Beta. That's what you pick. You could have picked so many B words.
Any issues with that?
Yep, thank you.
Okay, so Mr. Hawado, your lawyer will tell you next steps. You'll be processed and released. Next court date, July 24th, 2025, 8:30 in courtroom B. All right.
Thank you.
I wish they would say the county instead of just courtroom B. That's very hard for me to find.
And if we're able to then call Damon Gonzalez,
It's
please.
Boulder. It's Boulder. We're waiting to see if this is an inmate on the floor. That's what we're trying to find out.
Oh, we have two Gonzalez's. Damon Gonzalez, 25 CR 529.
How are you doing today, Your Honor?
Hi, good, thank you. All right. Counsel, anything we want to do, bond was set at $4,000, cash or your property based upon the history in the case.
Judge, I would like to address bond and then we can address,
No, I can't because he's doing all the counties. They're doing all the counties, but she's in Boulder County Jail. So I'm pretty sure that guy was in Boulder County because they're in Boulder County.
charges since they've been filed. If that's okay.
Yep.
So I would ask the court to consider modifying the bond. I think it's at $4,000 with a $400 cash option. I'm just asking the bond to be lowered to $1,000 with $100 cash option. I understand that Mr. Gonzalez missed court. As you can see kind of in the background of the case, there was some confusion with when the court date was actually supposed to be set. He was not in Boulder County when he was arrested. He was seen in another county. And what he reports to me is that the paperwork that he had been a different date. So essentially, I think there was some confusion there.
And I still have the paperwork.
Okay. And so I will note that he does have a number of community ties. He lives with his dad in Englewood. He has a job where he does a variety of things, landscaping, house restoration, tile carpeting, really whatever people need done. We talked about the importance of appearing for court. And he shares with me that his dad can help him get to court. And if he can't give him a ride, his mom would help him Uber here. He has a lot of support in the community. He's really just trying to get back on the right track. I'd ask the court to consider modifying the bond just to give him one more shot to do so out of custody. So I am asking for that lower secured bond with a cash option. Thank you.
All right, thank you. Mr. Rosenbaum.
Maybe, but again, he's doing all of the counties. It's Father's Day. It's Sunday. All the courtrooms are closed. 3 are open. 3 judges from Denver all worked yesterday. And they got the whole state that participates. All right. So like Glenwood Springs does not participate this way. So nobody from Glenwood Springs is here. But the rest, Arapahoe, Boulder, Denver, Adams, Wells, all the rest, they all their people who needed arraignment or first appearances or needed lawyers or just got arrested, they all zoomed into these 3 judges. So yes, Bobby, that judge is probably from this Division 6 in Boulder County, but that doesn't mean that these people are. This one is definitely Denver, 100%. So the guy that was sitting here earlier with a little tuft of hair, Denver.
Your Honor, I would ask for the bond to remain as set. This is a felony level theft. You failed to appear.
And you can only get Colorado judges right here.
I think there's reason to have concern that he'll come to court in the future. I think it's reasonably set.
All right, I'm going to deny the modification request. Judge Archuleta saw the defendant on a couple of occasions and told him about the return date, and then he failed to appear. And it seems like the county court judge set bond appropriately based upon his assessment of the situation. So we'll keep bond at $4,000 with the same terms and conditions. We can get you in hopefully quickly.
And is there still a cash option, Judge?
Yeah, cash option's fine.
And I guess I can just address charges. We are in receipt of the charges and waive any further reading and advisement and ask to set for preliminary hearing, please.
Okay, let me make a note of that.
I can separate a check, just not in the middle of a busy Friday night. I just can't. Won't. Could. Won't.
Okay, let's get a date for a preliminary hearing then, please. My
kids live with me and I hope they move out soon. pack your stuff and get out of here. Tell them that every day. They love it.
Okay, we can set the preliminary hearing with the county court judge, July 3rd, 2025, 9 o'clock, courtroom D as in Delta.
I would never in a billion years live with my mother. No, absolutely not. It would never happen.
That works for the people, Your Honor.
Thank you, that works.
Okay,
I'd rather live with my ex.
Ms. Land will tell you next steps. Mr. Gonzalez, that's your next bond return date if you bond out. If not, you'll be transported for your PH. And the judge will see you then.
I'm single. I can do what I want. My kids want to live here, they can. They don't want to live here, they don't have to.
Okay, and now any order or jail, is there any?
Whoever you want.
Okay, now we can go whatever order the court would like.
Oh, that's nice of you. Thank you.
I typed that one up, Peyton, because I didn't have it. I had 2 Gonzalez's, yeah.
More expensive for us.
We could
than
just
I was
go in
gonna-
alphabetical order if that's easiest for the deputies.
Do you remember that time? Whoa, I wish I could remember what courtroom this was. This was back when I was getting YouTube judges, I'm sure, but this was a judge. Oh, it's on the tip of my brain. So I know who it is now. It was all right. Back in 2023, I used to get Judge Shelley, and I think it was Hazlitt from Reno. Okay, no one else was getting them. They get them now. You can see them on other channels now because of YouTube judges. But Reno, it was just me. And I think it was Hazlitt. He would always get so mad when they wanted to do the docket in out. It wasn't him. It was an attorney in front of him when they wanted to do the docket in alphabetical order, because it's unfair. It's unfair to people with a last name of Z because they always go last. They've been going last their whole life. So it's unfair to do a docket with. So what the judge would do, what Hazlitt would do, is Monday, and Shelley, I think Shelley would too. Monday, they would go reverse alphabet. And then Tuesday, they would go alphabet. And then Wednesday, they would go reverse alphabet. But it's still not fair to the middle of the crowd. I know. I'm a middle child. And sometimes the oldest got to go first, and sometimes the youngest got to go first. But me, I was still in the middle. No, but this attorney would get absolutely mad, and he would tell the judge how wrong he was. Blah, 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 blah. I wish I didn't have to delete all my older videos because I would get that. He was really going off on the judge about, oh, what did he call it? Alphabet. I wish I could remember what he called it. He had a word for it. Not alphabet oppression, but it was something like that. Alphabet oppression.
Probably easiest for the lawyers and the judge. So we could call Dakota Bailey if we're ready on that matter.
So we are, Judge, except that I don't think there's any reason for it to be on the docket. That person's not down here. It's a straight
That makes
sentence.
sense. That sounds right.
So.
Okay. So whether we do, we just have her have a next court appearance date noted.
No, there's no future court appearance because it's just a sentence. It's not probation or anything.
Okay. Gotcha. I'll just make a note of no action taken. Hayden, do we need anything else on that?
Oh, Veronica, that
Okay, great.
sucks.
Sounds like the CJAs have it figured out. So we'll just note no action taken on this matter. Thank you.
That attorney would have a field day with
Then
you.
we have Ian Bane, 24M1216.
Bane?
All right, counsel, I don't think bond has been set yet, so whenever you're ready.
Ivy?
Yes, Your Honor. Brandon Rosenbach for the people. I understand that this case, the highest level of charge, I believe, is sorry, let me, one sec. My system's freezing on me a little bit.
Yeah, misdemeanor criminal mischief.
Yes. Sorry, the highest level of charge is an M2, so I believe there is a presumption for a personal recognizance bond. I do think there are circumstances to justify a CSP bond in this case. I would not be asking for a high bond, but I think a $2,500 cash surety or property bond, given the circumstances and what I see as just a significant recent criminal history, but also that he has two open cases. One of them is a felony probation case. The other one is an attempted trespass one dwelling. And then also, frankly, with the facts of this case, which I think were fairly concerning and seem to be unprovoked and have no reason, I think a low secured bond of $2,000 is appropriate in this case with a cash option.
All right, Ms. Land.
So, Judge, I believe that a PR bond is required by statute, specifically CRS 16-4-113. Because the highest charge is an M2, he's required to have a personal recognizance bond unless the court makes specific findings, which are in subsection A through F. I don't believe any of those can be found at this time. He is on probation, but it is not pending revocation. He does have community ties. He lives at the Bluebird, where he is supposed to be accessing full services. And I don't think any of the other A through F circumstances are present. He has not refused to sign a PR bond. He has been identified. There is no indication at all from these charges or the charges in which he has pending that a secured bond is necessary to prevent imminent bodily harm to himself or another. He has ties. He has not, etc. So unless the court makes specific findings under subsection A of 16-4-113, I think a PR bond is mandated by statute.
All right, thank you. Let me just review the arrest report again. Yeah, there is some concerning behavior here, but it is a low-level charge, and statute requires or strongly suggests a PR bond. So I'll set $1,000 PR bond. No contact with the victim, no contact with the Boulder County Library located at 10001 Arapahoe. I think this is a situation that could have been much more serious because of the defendant's alleged activities. Why don't we get another court date, please? All right. Well, Mr. Bane, you understand
Delivery.
those protection order restrictions, can't see the McLaughlins, can't go to the Boulder Library until it's modified?
Yes, Your Honor.
Okay, so we'll set you for next court date, July 24th, 2025, 8:30 in courtroom B.
And Judge, can we also pull in the 25M1186 case, please?
886.
Oh, I think it's 25M1186.
Okay. Yeah, we'll join that for the next hearing. All right. Thank you, counsel. Then we have Mark Brooks, 24.
I don't know what he did in the library because I wasn't paying attention, but it must have been bad. He must have been talking really loud.
607.
Yes, sir.
All right, so this again is a misdemeanor domestic violence complaint. I don't think bond has been set yet. I see you were talking with the deputy, so whenever you're ready, Miss Land.
We're ready. Sorry about that.
Okay, no problem.
So Judge, I can just jump into my bond argument. I recognize that Mr. Brooks has another hold, but I'm still asking the court to consider a personal recognizance bond here. I understand that there's criminal history and I understand the allegations, but if everything in the arrest narrative is taken as true, I do think that there are some concerns here that perhaps Mr. Brooks was not the person who began this altercation. As you can see, he called the police. He stated that he was bit. He had those physical marks on him. So I think there's a lot more going on here. And I'd ask the court to consider that. I will also share with the court that he has a stable job. He works at Circle Graphics as a machine operator. He was supposed to work last night. He's on the 7 p.m. to 7 a.m. shift. So he's hopeful that if he's released from custody, he'll still be able to go back to that job. He's been working with a number of various service providers, getting therapy and other things. He's been working with Porchlight, with Salute Clinic. He is also taking classes through, or starting classes through Men and Women Seeking Empowerment. He has housing. He can stay with his mom who lives in Fort Lupton. I'm asking the court to consider a PR bond, even though I recognize there's criminal history and that might not be the normal course of events. But I do think given everything he's been trying to do in the community to stabilize himself, as well as some of the potential things that happened in this case, I think there's more than really what we can see from just the initial report. I think that a PR bond or a lower secured bond with a cash option is appropriate.
All right, thank you. Mr. Rosenbach.
Judge, I'll be asking for a $3,000 secured bond with a $300 cash option. I think a reasonable, fairly low secured bond is what's appropriate in this case. It's a domestic violence assault. He's on a parole hold and he's got criminal history. I'm gonna have nothing further.
Okay, yeah, I think that's a fair amount. The defendant does have the criminal histories on a parole hold. There does seem to be a little more to this allegation than a typical DV situation, but it needs to be sorted out. So I'll set the low secure bond just to ensure the defendant's compliance and because of his history, $3,000 cash surety or a $300 cash alternative. No contact with the victim, no weapons, and then he's going to have to verify his address. So that's probably just his mom's address before bonding.
And Your Honor, would you mind just advising him of the
Salted caramel.
protection and firearms?
Yeah, thank you. Mr. Brooks, you're going to have no contact with the victim here, Diana, and you have to.
You don't know how much I love that you said were. Because you know me.
Relinquish, or you have to have no weapons as well. Got it?
No problem, sir.
Okay, let's get a court date then, please. Okay, next court date, July 17th, 2025, 1:30 p.m. in Longmont Courthouse, there on Kimberg.
Bobby, are you still here? I don't know if you're still here, but I think Longmont has Meredith. You know that judge? She's really pretty. I can't remember her last name though. I'll see if I can get her. I'll see if I can get him and her. Four packs.
Thank you.
8 in each
All right,
pack.
thanks, Council. All right, then we have Eric Brown, 25 CR3.
I think he was the one on the floor, guys. Nope, there's still something on the floor.
Okay, looks like he was picked up on an arrest warrant from an alleged probation violation. Bond was set at $5,000 as it had been set before. So any bond argument?
Yes, Your Honor. I am going to ask the court to consider modifying to a personal recognizance bond, and if not, a lower secured bond with a cash option, specifically $1,000 secured with a $100 cash option. I recognize that we have this complaint pending, but I will note that in the complaint, it looks like he did make efforts to get to probation, but was just appearing late. My understanding is that he was trying to get probation transferred to Longmont, which is where he lives, but they continue to require him to get to Boulder, and he just was not able to get there. The reason I'm asking for a lower bond is because he understands that he needs to check in with probation, even if it's in Boulder. And I just want to give him one more opportunity to try to do so since he has made efforts. He does have community ties. He lives in Longmont with his parents. His children, who are age 15 and 14, live in the household with them as well. He does have a job with BK Welding. He's been there for about 4 months and he's supposed to work tomorrow. Again, often we'll see cases where there's no effort made whatsoever. He did get to probation a couple times and then it was out of reach for him to get there again. So I'm just asking for that opportunity for him to try out of custody one more time.
All right, Mr. Rosenbach.
Judge, I'm asking the bond to remain as set. I think there's concern that he's going to comply and come to court in the future. Looking at this case, he already did have one chance on probation. This was the second chance on probation. He messed the intake appointment. This is an appropriate bond at this point.
Yeah, I see that there was a bond revocation just a few weeks after the plea agreement, and then this is the second bond revocation just 3 months after that. I think bond is appropriately set to ensure the defendant's compliance and appearance at future court dates. So we'll keep bond as set, and then you'll appear before probably Judge Bakke, and you can take up next steps. So let's see when the next court date is.
Judge,
He'll stay in county court, it looks like. Yeah.
I think the only thing we might need to address, depending on when we set the court date, is his right to a hearing because he is in custody.
Okay.
If we're going to set it in short order, if he's going to waive that right and set farther out.
Okay, let's see what the court date would be for the hearing. We have July 10th, 9 o'clock, courtroom C.
Is there anything sooner?
Yeah, we're checking. Thank you.
So you have the right time to hear. I think there would so my advice would be to just wait, right? Unless we can't get a Supreme Court date. And then we'll set
Mr. Rosenbach, is it still 14 days if he's in custody?
I believe so, yes. Unless Ms. Slam thinks something different.
No, that's right, Judge. And if we can get a sooner date, he'll waive. If not, he's not going to waive so that we can get that 14-day hearing, please.
Okay. Okay, let's just check for a moment with supervisor.
Meaning for the DA's sake, I anticipate we can resolve it, but I'd just rather get it done sooner.
No, I understand.
For Division 7, I'm not seeing that they have a public defender docket within 14 days, which I think is the problem Payne's running into. So if we can set it on a non-public defender docket, we can do it within 14 days.
All right. Thanks, Ms. Johnson.
I mean, I can't really accept that. Can we set another division?
Not set it in another division.
Can we set it on a jail docket?
That we could do. we could do June 27th. Is the expectation that I might proceed to a testimonial hearing?
No. I mean, not, I can't say no for sure at this time. I don't think so. But I will get an attorney on it today or tomorrow and then can have them communicate further with the division and the DA.
Yeah, my only ask would be if it plans to proceed to a hearing, that you let the division know so they can just make accommodations for the jail docket, but otherwise we can set it on the 27th at 1:30.
That sounds perfect. Thank you for accommodating.
Yeah, no, it looks like with the nature of the complaint, it's probably not lengthy and it may be just a resolution. So while we set for the jail docket, thank you, Ms. Johnson, June 27th, 2025, 1:30. And if it is going in a different direction, Ms. Land, like you said, maybe reach out and we can find a better date.
Yeah, absolutely. Thank you.
All right. Okay, thank you. We'll see you then. Okay, then we have the Curio matter 24M1220. Oh, do we have? Okay, gotcha. Here we go. Areli. She appears.
Good morning.
Good morning. All right. Looks like we have to address bond on this misdemeanor complaint of assault.
Sure. Yes, Judge. I would be asking the court to set a personal recognizance bond, noting that she's a CPAT category of 1 with a raw score of 1. The bond commissioners recommended a personal recognizance bond with no supervision. I think that's what's appropriate. She is currently pregnant. She's also working 2 jobs. She works at a retail store and is a manager at one of the wing stops nearby. She does live with her parents in Boulder, but is also paying rent there. All that to say is she is stably employed and stably housed. She's lived in Boulder for 20 years and her family's here, so I don't think she's at all flight risk. If the court has any concerns about community safety, I'd ask the court to address those with non-monetary conditions.
All right, thank you. Mr. Rosenbach.
Judge, I have no objection to a personal recognizance bond with the conditions recommended by the bond commissioner.
Yeah, the defendant does appear as a low risk. There is minor criminal history, but the defendant was on probation, which is a little problematic to have these new charges. But I will set a $1,000 PR bond. No contact with the victims. No weapons. No alcohol, no drugs. Alcohol monitoring. Substance abuse at probation's discretion, and then report to Denver probation upon release. All right, Areli, do you understand that you can't have any contact with the Sanchez's and you can't have any weapons?
Yes, sir.
Okay, and then we'll get another date. July 24th, 8:30, courtroom B. All right, so Ms. Curio, you'll be out of custody, so your lawyer will tell you next steps and how to get to that court date.
And Judge, if we're able to actually call another thing out of order, we want to call stop, please. And then that's the last one, I think.
All right, Riley Stott, 25M605.
And Judge Brandon Rosenbach for the people, we have no objection to a personal recognizance bond in this case with conditions recommended by the bond commissioner.
All right, Ms. Land, anything?
If that's what the court is going to do, then I have nothing to add.
You know, it seems appropriate. I'll set bond in the amount of $1,000 PR. No contact with the named victim or the victim's residence. No alcohol. No weapons. Substance abuse monitoring at probation's discretion. All right, Ms. Stott, do you understand you can't have any contact with Joshua Petty or the address until and unless there's some modification?
Yes, Your Honor.
Okay, and no weapons either. So we'll get another court date.
And I apologize, Your Honor, I actually did have one ask. If she could be authorized one civil standby, that would be appreciated.
Okay, we'll have a civil standby and you can work that out with law enforcement to retrieve any possessions. July 24th.
Your Honor, sorry for interrupting, but my name is Joshua Petty, and I'm like the victim on this case. I was just wondering how we would be able to get the restraining order like lowered, because she is like, her family is the family that's helping me out a lot to get me to work and stuff and to get me to barbering school. And so without me being able to have contact with her is going to be like really hard for me, because I don't have really nobody else to lean towards. And like this whole situation on the case was like very not meant to be. It never happened before, and like this is like the first time. So I was just wondering like how like that process works, just because like I do have to get to work and I don't work in town, and I live in Longmont, and I work out of town, and I work at a Vavalon. And so I was just wondering, yeah, like what I could be able to do to like get that lowered, because she is not a threat to me and she doesn't put me in no harm or nothing. I'm just trying to figure out on my side of things as well.
Okay, I hear you and I understand your concerns. When these cases are first filed, our first and foremost approach is for victim safety. So what we'll do is we'll keep the restraining order in place for now, but you'll talk to the prosecutor, you'll talk to victim services, Mr. Petty, and then if there's a request to modify the protection order, that can be done quickly. And at the very latest, you would be able to address when we have court on July 24th in Longmont, but you should probably be able to get a modification in place quicker. I just want to make sure you talk with victim services and make sure that the prosecutor is on board as well.
All right. Thank you so much. And I really appreciate it, Your Honor.
All right.
Is there really fast one last question? Would they be able to get in contact with me? Sorry for stuttering. Would they be able to get in contact with me, or would I have to get in contact with them?
Mr. Rosenbach, how would you want to deal with that? You're just a weekend prosecutor.
I am for this case, but generally they should be reaching out to you, Mr. Petty. You can also just look up kind of general information for the DA's office, and if you call or email, then they'll put you in touch with the right person about how to go about changing the protection order.
All right, thank you so much. I really appreciate it.
I made a note to the next judge, that you may be making that request, so they'll be ready.
All right, thank you guys so much. I really appreciate it.
Okay, thank you.
All right, bye-bye.
All right, if we're back alphabetically, it looks like we're on the Chelstrom matter.
And Judge Brandon Rosenbach for the people. The people are requesting a high secured bond on this case. Oh, sorry, he's still walking up.
Oh, okay.
Yeah, he's almost here.
All right, 25 CR 849.
And Brandon Rosenbach for the people, like I was saying, the people are requesting a high secured bond in this case. I think I'm incredibly concerned for this victim's safety. If you look at the original underlying case when this one got brought up, it's incredibly concerning. It's a complex fraud where Mr. Chelstrom essentially is using fraudulent quitclaim deeds to try to steal an at-risk victim's home. And then he is violating the protection order. He is going to her home and then being aggravated while he's at that home. Frankly, I'm incredibly concerned for this at-risk victim. I think both these cases are incredibly serious, and he is escalating his behavior. He is not listening to the court while he is on felony bond. And ultimately, he also has supposedly a large fixed blade knife and open containers. He's on felony DUI probation in Jefferson County. Ultimately, Your Honor, I'm asking for somewhere in the range between $30,000 and $50,000 secured bond. I think there is an extraordinary risk to this victim if Mr. Chelstrom does not have a high bond in
Triple that. Triple it.
this case.
All right, thank you. Ms. Land?
Your Honor, I'm asking for a much lower secured bond with the cash option. Mr. Chelstrom is not going to be able to post a high bond at all. He tells me that he only has about $100 that he could spend on this. And he does have another bond out of Jefferson County that's holding him right now that is significant as well. So I think that's important to take into account. I understand the people's concern. I do think in this case, I do think this case feels less aggravated, given that a lot of the contact in this case is consensual. My understanding is there also might be some contact that is coming from the named victim. Understanding there's a protection order that protects Mr. Chelstrom, I do think that that is part of what's going on in the background here. He always shows up to court. He shows up to court. He's already applied for a public defender's office Ms. Briggs represents him while he's out of custody. I'm not concerned about him being a flight risk. He can live at a friend's house in Lafayette. He works doing handyman work, painting, things like that. We have discussed the protection order at length. He understands that he cannot have any contact, and there are no exceptions to that. So I would be asking the court to consider a lower secured bond with a cash option.
All right, thank you. Now, this is a concerning situation, the particular situation and the defendant's criminal history. I think that the defendant poses a risk to the victim, as well as having a history of just non-compliant behavior. So I'm going to set bond in the amount of $50,000 cash surety or a $5,000 cash alternative. No contact with the victim, Miss Ashley, no alcohol, no drugs, no weapons, substance abuse monitoring at probation's discretion. If there's a plan in place, I'm sure the judge would listen to a bond modification request, but right now, for victim safety and other reasons, I can't set a modest bond. So, Mr. Chelstrom, you understand, no contact with Miss Ashley, no weapons? Yep.
Yes.
Okay. Let's get another court date then.
Are you up north? You're up north, right, Terry?
Okay, next court date, jail court, June 17th, 2025, 1:30 p.m.
We can't make those fluffy biscuits up
All right, I
north
think
like they do.
Deputies wanted
down
us
south.
to skip Contreras until the end so we can move to Mr. Coy, Gregory. All right, so Mr. Coy was picked up on an arrest warrant back in May.
Our atmosphere doesn't allow them to get as light and fluffy and tall like they do down south. You can try. You can get the white lily flower from down south and try, but it's still not going to be like a southern biscuit. It's just not.
Bond was set at $5,000. So any argument?
Yes, Your Honor, I will just share with the court that Mr. Coy doesn't have any amount of monetary bond, any amount of money that he could post for a monetary bond. He is going to be he was in Denver before, but is going to be staying in the shelter here in Boulder so that he's closer and be able to get to court. Right now he's unemployed, but he's working on gathering all the documents that he needs to be able to get gainful employment again. If the court is not willing to set a secured bond, I would be asking for a very
West
soon court
Virginia.
date so that we could potentially resolve. I don't know if there's already an offer in this case, but we just to resolve as soon as we can.
Okay, thank you. Mr. Rosenbach.
Judge, I'm asking for the bond to remain as set. The note I have from the last time that Mr. Coy was in court was that the judge quoted that he gets one more
Country
chance.
roads.
Frankly, at this point, the bond's reasonable as set to ensure that he's going to comply with his sentence, continue coming to court.
I'll deny the bond request. Similar to the other case, as soon as he pled guilty, he picked up a complaint and then had the history of failing to appear and actually had to be arrested. Bond is appropriately set, but we will get a court date as soon as possible to hopefully resolve the situation.
Can I just ask, Mr. Rosenbach, I know this is a VRA case. Is there an offer? And if so, could we set it sooner? Or what are your thoughts? Sorry, Judge. It's just so we can figure it out as quick as possible.
And I'm being told that June 27th is the next court date.
It looks like there is an offer in the works, and then I'll give an urgent task to the DA on the case so that they can start getting to work on it.
Okay, that sounds good. Thank you.
Yes, I know the may I speak?
E is an echo. E. Yeah. At what time? Okay. So 9 o'clock, June 27th, 2025 in courtroom E. All right, now we have the Fazio matters 25M1213 and 863.
And Judge Brandon Rosenbach, for the people are asking for the bond to remain as set on 25M863, and then the new case, the violation of the protection order, the people are asking for a $3,000 cash surety or property bond. Ultimately, he failed to appear in the prior case, and then he immediately violates the protection order, and he does have some pretty recent criminal history. I think that's reasonable.
Okay, thank you. Ms. Land?
Your Honor, I'm asking the court to consider PR bonds in both cases. There isn't any monetary bond that Mr. Fazio would be able to post. With regards to the last failure to appear, it sounds like he lost his paperwork and lost track of the court date. We discussed the importance of showing up to court. He does live at 1440 Pine, which is the program called Together, where he receives mental health services and youth services. I don't want to go too much into the facts here, but the allegations make it seem like the named victim was in at his property. He understands that if she's there, even though it's not her house, he cannot be there. And we'll discuss kind of some other avenues that he can approach this in the future. I will also note that he was incredibly compliant with police in this case. I get that there's some criminal history, but I just, the situation here is a little bit different. I would be asking for the court to set that PR bond. I will also note that I'm asking for a civil standby. Again, understanding that although it's his apartment, if she's there, this Your Honor doesn't have any ability to tell her to leave, so he would need a civil standby to get his belongings, and he understands that.
It's rare that we see a CPAT score of 4 with relatively, lower level charges. I'm going to deny the request to modify the prior bond, and I'll set bond in the amount of $3,000, $300 cash alternative. In the new case, defendant was in non-compliance with the old case with his failure to appear, and then has picked up these new charges. So he obviously has an issue with either compliance or self-control or both. No contact with the victim, as Fazio, no weapons. We'll authorize the civil standby, and we'll get the next court date. July 11th, 8:30 in courtroom C, as in Charlie. All right, then we have Carlos Feriera, 25M1214.
Good morning, Your Honor.
Good morning, sir.
And Judge Brandon Rosenbach for the people, I have no objection to a personal recognizance bond in this case with the conditions recommended by the bond commissioner.
Ms. Land?
Judge, I would also be asking for a PR bond. The only record I'd like to make is regarding the protection order. And I would be asking for it to mirror the protection order in 25 DR 657, which I believe right now allows for talking with the parents app, and I'm not exactly sure what else. I can pull it up, but I would just be asking for the protection orders to mirror so that he can have contact with his child.
All right, we'll set bond in the amount of $1,000 PR bond. Defendant is a low risk with a not a significant criminal history, but there are some concerns with the domestic violence and the protection order, but that was a long time ago. So I'm concerned that there may be more going on here. So we'll have some added bond conditions of no alcohol, no drugs, and substance abuse monitoring. If it ends up that that's not the concern, then the defendant can ask to modify that. No contact with the victim except for third-party contact for parenting and through talking parents. The restraining order will mirror 25 DR 657. No weapons as well. So Mr. Feriera, you understand no contact with the mother? You understand that, sir? No contact?
Yes, no contact with the victim.
Yep, except as permitted. And if you're in the gray area, better
Get her name out of your mouth, sir.
not to have the contact. Okay, so we'll get the modified restraining order to you. And you'll be processed. We'll give you another court date. July 24th, 2025, 8:30, courtroom B as in Bravo. Ms. Land will tell you about next steps. So I'll sign that whenever you're ready. I think we'll just modify that. Yeah. All right, it looks like we have the other Gonzalez case, Hannah, 25 CR 847.
This whole docket is let's make a deal. You want door C, door B, or door A?
All right, she was arrested for this menacing. Bond has not been set yet. So any argument from the people?
Yes, Your Honor, the people would ask for a $5,000 secured bond, understanding that Ms. Gonzalez does not have any criminal history. Looking at the facts of this case, I do think there are some concerning facts that give me concern for the victim's safety. On the flip side, if Your Honor is inclined to do a personal recognizance bond, I just would ask for pretrial supervision. And I have nothing further.
Or Ms. Land?
Yes, Your Honor, I would be asking the court to issue a personal recognizance bond. And with pretrial supervision, that's fine. That's something we discussed when we were speaking before, that would likely happen.
Let's make a deal with a game show. And you got to pick which door you wanted your prize from, or you got to pick. You had to guess which was the best, whatever door, whatever, to get these prizes. It was pretty good. It was funny.
In this case, as you can see, she's a CPAT category of 1 with a total score of 2. She has no criminal history whatsoever. I understand that there are concerning allegations in this case, but I do think that she can be monitored safely in the community with pretrial supervision and any other non-monetary terms and conditions that the court wishes to authorize. I can tell the court that we did talk at length about the protection order and the no contact requirements, as well as no alcohol, no drugs, no weapons. And she understands that that will be a requirement for her to stay out.
I know. I said I wasn't going to do trials. I was going to go back to regular clips. And that means either DUIs or domestic violence. That's what that means. Although I have a great trial. I want to play. But no, we're going to stick with clips.
Custody on bond. She has a friend's house that she can stay at, which is not with any victim. And she will be able to get to and from court by taking the bus. And so I would ask the court to authorize that PR bond with any additional supervision that the court thinks is appropriate.
All right, thank you. It is concerning, especially with the alleged use of a deadly weapon. But given the defendant's minimal history and presenting as a low risk, I will approve a PR bond of $1,000 placeholder. No contact with the victim, yes. No alcohol, no drugs.
It's a civil trial, Kelly, and here's what happened. This guy worked for this company, and the company was using a lot of illegal immigrants and not paying them correctly, and they were paying people that weren't. There were people on the payroll that didn't even work there. And all this money was going out to pay these people. So the whistleblower was murdered. The company murdered the whistleblower, allegedly. It's a civil trial because it's the wife of the murdered employee that's suing the company.
No weapons, substance abuse monitoring, at probation's discretion, no firearms, and pretrial supervision as a requirement as well. So you'll be released, Ms. Gonzalez, and we'll get you another court date here. Next court date, June 17th, 2025, 1:30 at the jail where you're at. So if you're released, make sure you come back to the jail to appear in court. Your public defender there will tell you next steps.
I'm sorry, did Your Honor advise her of the protection order?
Oh, yes, ma'am. If you acknowledge you can't have any contact.
I have it. I still have it. I'm just waiting to play it. I have to play some domestic violence and DUIs first.
Unless this is modified with
Yes,
Jordan Yates.
Yes.
Okay, great. Thank you.
With a little house ceiling every once in a while, too. Don't forget the house ceiling.
Next, we have John Hudson, 25 CR 850.
Judge, he did not join us today. I would ask to just reset this for tomorrow on the jail docket.
Is he just a refusal?
Correct.
Put a hands-on order out there, Judge. Hands on. Get him here.
Okay. So Peyton, is that what we do? We put on the jail docket? So 6/16/25 at 1:30. Okay, great. So we'll do jail docket 6/16, 1:30, and the judge will see him then.
Hey, American Courts had a Brandon in his too, didn't he?
Thank you, Judge.
Thank you. And then we have Matthew Irish who will work his way here.
He's approaching.
Great. All right,
It's
Matthew
him.
Irish appears in custody.
Matthew Irish, it's him. He was the lump on the floor. We found him. It was a person. Here he comes.
He was picked up on this misdemeanor complaint. I'm looking at the bond application now, Mr. Rosenbach.
And Judge Brandon Rosenbach for the people. I do understand he's a CPAT 4, and they did recommend a cash surety or property bond. But given the level of charges, given the facts of this case, I'm not going to object to a personal recognizance bond.
Yeah, I tend to agree, Ms. Land.
If you agree, Judge, then I don't need to make a record.
Yeah, this is an issue where the defendant has a lot of low-level charges and offenses that seem to be substance abuse in form. So I think that we need to address the underlying situation here and get the defendant some services. It looks like there may be some other outstanding matters, so I'm not sure if the defendant is going to be released, but I'll set bond in the amount of $1,000 PR. No alcohol, no drugs, alcohol and substance abuse monitoring at probation's discretion. I think we're just going to have to get some services in place for Mr. Irish for him to have success. We'll get the next court date. I'm being told July 24th, 2025, 2:00, courtroom B, as in Bravo. Mr. Irish, your lawyer will tell you next steps. I'm not sure if you're going to be released, if there is this warrant out of Denver. If you are released, remember to come to court July 24th, 2025, 2:00. If you're in custody, you'll be just presented to the judge at that point.
Thank you, Your Honor.
All right, we have Jackson Long, 25M 349. All right, defendant appears on an arrest warrant. The bond was set at $1,500. Any additional argument, Ms. Land?
Yes, Your Honor, I would be asking the court to consider personal recognizance bond. The current bond does have a $150 cash option. As you can see, he's still here. He can't afford that. So I would argue that with that knowledge, any amount of monetary bond would be a violation of his constitutional rights. I understand that he missed court. My understanding is that he was celebrating his sister's graduation. I understand that's not a very good excuse, but unfortunately that his sister is kind of the only family that he's really got. His parents passed away when he was young. He lives in Longmont. He is unfortunately homeless, but is in Longmont, so we'll be able to get to court in Longmont. if the court isn't willing to modify the bond, I would really just ask for the soonest possible court date. The only charge is a level 1 drug misdemeanor, and I think it should be pretty easily resolvable.
Mr. Rosenbach.
Judge, frankly, I think a personal recognizance bond is reasonable here. I do have some concerns because there was a failure up here, but given the nature of the charges, the level of the charges, and I think a diversion offer being on the table at one point, I think it's reasonable to give him one more chance on this case.
Now, this is a case where, similar to the other gentleman, there seems to be a history of substance abuse and challenges relating to that. There's this history of not appearing, and I know Judge Hanselman had set the bond as she thought was appropriate. But given that the defendant has been in custody now, and there's diversion offer, I'll set bond in the amount of $1,500 personal recognizance, no alcohol, no drugs, substance abuse monitoring at probation's discretion. We'll get a court date and hopefully resolve these things, and hopefully there can be a resolution, Mr. Long, that can be a bit therapeutic instead of just punitive. So let's see what the next court date is. We could set the matter at Longmont, so it's easier for the defendant, July 24th, 2025, 1:30. Mr. Long, your lawyer will tell you next steps. Make sure you appear. If you don't, there's going to be some worse consequences.
Thank you, Judge.
Thank you, Judge.
$300 bond instead. PR, of course.
All right.
All right. That's good. That was good. Thank you so much for coming out, guys. I really appreciate it. I am going to show that trial, but instead it was 3 weeks long. So I have off today, but it's my daughter's birthday and I have lots of plans. But I'm going to try to cut up that video to take it from 3 weeks to like 4 hours, maybe 6 hours max. I don't know. And I might put it out as a video series instead. So I don't know. I'm going to work on it. Maybe today, maybe not, and get that out. Yes, Tiffany's birthday. Taking her to the casino. She loves the casino. So, all right. You guys have a great day. You should get popped right over to OJ, or I will see you all later. Bye, guys. Thank you.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Dreaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes hear a sky so blue. In her jokes there's a truth so true. Wicked streams she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh there's no